Someone forged a deed on her house. Her name is Dorothy. She is 74 years old. She spent 31 years as a registered nurse at a hospital system outside Tampa. She retired in 2019. She paid off her home in Pinellas County, Florida in 2021 after 23 years of mortgage payments. The deed was in her name. The house was hers, free and clear. Someone printed a fake deed, drove it to the Pinellas County Recorder's office, handed it to a clerk, and the clerk stamped it accepted. No phone call to Dorothy. No cross-reference against the existing title. No verification of the signature. Accepted, filed, recorded, done. By the time Dorothy discovered what had happened, she was $4,200 deep in legal fees, fighting to prove she still owned her own home. 4 months of certified letters and attorney consultations and court filings and sleepless nights in a house she had to legally argue was still hers. The program that would have caught the fraud within 24 hours was free. It existed the entire time. Her county offered it. Her county never told her about it. Not when she bought the home. Not when she paid off the mortgage. Not when she turned 65. Not once in 23 years of ownership. Dorothy is not unusual. Dorothy is what happens to a retiree with a paid-off home who does not know about 5 pieces of paper that could have protected everything she spent her working life building. If you own your home, especially if it is paid off, you are the most attractive target on your block. Not the renter next door, not the family with an underwater mortgage. Your paid-off house is not a fortress. It is an unguarded vault with your name on it in a publicly searchable government database that anyone in the world can access in 30 seconds. Today, I am going to show you the 5 documents that lock it up. Welcome to the Digital Defender. Every week, this archive delivers the investigation, the financial industry, the legal industry, and the real estate industry. What prefer you never find. Subscribe now. Flip the notification bell to all, because the 5 documents I am about to walk you through have been sitting in county offices across America for decades, waiting for the retirees who own paid-off homes to file them. Most never will, because nobody told them to. Smash the like button right now, not at the end. Because every like pushes this investigation into the feed of one more retiree with a paid-off home who has no idea they are the most targeted demographic for deed fraud, creditor judgment liens, and property tax seizure in America. One tap, do it now. This video is for educational purposes only. It is not legal, tax, or financial advice. Consult a qualified attorney before making any decisions about your specific property situation. Here is what a paid-off house looks like to the wrong people. It is searchable in public records in 30 seconds. The equity is visible and unprotected with no lender lien, monitoring the ownership chain. And statistically, the owner is over 65, possibly living alone, and has never heard the words Homestead declaration. There are 3 groups that can come after your home equity. Scammers who forge deeds and steal your property outright. Creditors who attach judgments from medical bills, lawsuits, or personal debts directly to your home. And the government, including the IRS and your own county tax authority, who can place liens, levy your property, or seize it for unpaid taxes. 5 documents protect you from all 3. Most of them are free. Most take less than an hour to file. The difference between having them and not having them is the difference between keeping your home and losing it. Document number 1. The Homestead Declaration. When you file a homestead declaration at your county recorder's office, state law protects a specific amount of your primary residence equity from most unsecured creditors. Medical bill collections, civil judgment recovery, credit card companies that want a default judgment against you, they cannot touch the protected equity. The amounts vary dramatically by state, and in some states they are extraordinary. Florida and Texas protect unlimited equity on your primary residence. A creditor cannot force the sale of your Florida or Texas home, regardless of how much equity you have built. Ohio protects $182,625. Nevada protects $65,000. Massachusetts protects $1 million for homeowners over 62. California's protection ranges from $361,000 to $722,000, depending on your county's median home price. 1 page, notarized, filed at your county recorder's office, free in most states. 30 minutes. It could protect hundreds of thousands of dollars of your home equity against unsecured creditor claims. When wealthy people purchase a home, their attorney files the homestead declaration before they leave the title company. It is not optional on their checklist. It is just done. For most retirees, nobody ever mentioned it existed. Go to your county recorder's website this week. search Homestead Declaration, find the form, fill it out, get it notarized, file it. That is document 1. Document number 2, the property fraud alert. This is the document that would have saved Dorothy in Pinellas County $4,200 in legal fees and 4 months of nightmares. Here's how the deed fraud playbook works in 2026. Scammers search public property records for free and clear properties in 30 seconds. They target older owners specifically. They forge a deed. They walk it into the recorder's office. In most counties, documents are filed first and verified never. The clerk stamps it accepted because there is no system to question it in real time. Once recorded, the scammer either pulls a hard money loan against your property or attempts to sell it outright. By the time you find out, they have already borrowed against your equity and you are spending thousands in legal fees, proving you still own your own home. The fix is almost insultingly simple. Most counties in America now offer a free property fraud alert program. Go to your county's website, search property fraud alerts, sign up, enter your name and property information. Done. 5 minutes, zero cost. From that point forward, you receive an email notification within 24 hours anytime anyone records anything against your property, a deed, a lien, a transfer, anything. That one notification would have caught the fraud against Dorothy the same day it was filed. She would have called the recorder's office, flagged the forged deed. The nightmare would never have started. Your county has your name in their property records right now. They know you own your home. They have your mailing address. They have never once sent you a letter explaining this free program exists. Not when you bought the home, not when you paid off the mortgage, not once. Because there is no law requiring them to tell you. And the revenue from your property tax bill costs them nothing in notification expense. Go sign up today. 5 minutes, zero cost. Now, before document 3, I need to address something. The standard version of this advice always leaves out because it is uncomfortable and because most people who give this advice have a financial incentive not to bring it up. The IRS. If you owe back taxes, the IRS can file a federal tax lien against your home. A federal tax lien is a legal claim against all property you own, including your house. It attaches automatically when you owe a tax debt and do not respond after the IRS sends a formal notice and demand for payment. Once filed, it becomes public record. It appears in the county property records alongside your deed. It makes your property essentially unmarketable until the lien is satisfied. For retirees, this is more common than you think. You miss a quarterly estimated tax payment during a hospitalization. You do a Roth conversion and forget to adjust withholding for the resulting tax liability. You receive a lump sum Social Security back payment that spikes your bracket in a way your prior year withholding never anticipated. The IRS sends a bill. You set it aside with the other mail. 6 months later, there is a lien on your home. In 2025, the IRS issued over 760,000 levies, including bank accounts, wages, Social Security benefit offsets, and federal tax liens filed against hundreds of thousands of properties. Retirees on fixed incomes are disproportionately affected because they lack the liquid cash flow to respond to an unexpected tax bill quickly. The Homestead Declaration in Document 1 does not protect you from the IRS. Federal tax liens override state homestead protections completely. Federal law supersedes state creditor protection in this specific category, and the IRS knows it. That is why staying current on your taxes is the non-negotiable foundation underneath everything else in this video. Open every letter from the IRS. Every one. If you owe money, set up a payment installment agreement immediately. An active installment agreement stops the IRS from escalating collection action as long as payments are being made. Taxes current. IRS correspondence opened. That is the foundation. Share this video right now. Send it to one person you know who owns a paid-off home and has never mentioned filing a homestead declaration or signing up for property fraud alerts. Right now, before you continue watching, the 5 minutes it takes them to sign up for a fraud alert is the 5 minutes that stands between their paid-off home and 4 months of legal hell. Document number 3. Enhanced title insurance. When you bought your home, you received a standard title insurance policy at closing. Most homeowners accepted whatever the title company put in front of them without asking a single question about what the policy covers. Here is what a standard title insurance policy covers. Defects that existed in the title before your purchase. Forgery that occurred before your closing. Hidden liens from a previous owner. A standard policy is rear-facing. It looks backward. It protects against problems that existed before you closed. It does not cover what happens after you close. If someone forges a deed on your property next year, your standard title insurance does not cover the legal fees to fight it. You are responsible for your own legal defense. At $20,000 to $40,000 in litigation costs for a complex title fraud case, that is a devastating bill that lands on top of the emotional trauma of having your ownership threatened. An enhanced owner's policy faces forward. It covers forgery of documents executed after your closing, identity theft property transfers, fraudulent deed conveyances that happen in the future, and in most cases, it covers the legal fees to fight the fraud, which is frequently the most financially damaging component of the entire experience. This is not free. It costs money to upgrade. But here is the question you should ask your title company this week. Is my current policy standard or enhanced? If it is standard, what does an upgrade cost? One phone call, 5 minutes. If the answer saves you $40,000 in legal fees at any point in the next decade, it is the most valuable 5-minute call you make this year. Document number 4, the Revocable Living Trust. This one is specifically about removing your personal name from the publicly searchable property record and keeping your home out of the probate system when you pass away. When your home is titled in your personal name, it is public record. Anyone can search your county's property database and find your name, your address, your property's assessed value, and whether the mortgage is paid off. Scammers, creditor collection firms, and judgment recovery agencies all start with a public record search. Your paid-off home with your name on it is a signal in a searchable database. When your home is held in a revocable living trust, your personal name does not appear as the direct owner in the property records. The trust name appears instead. The Patterson Revocable Trust of 2026, whatever name you give the trust is what appears in the database. You still own the home, you still live in it, you still control it completely. Nothing changes in your daily life, but the publicly searchable visibility of your personal name attached to a free and clear property disappears. Scammers who search for elderly homeowners with paid-off properties skip trust-held homes. They look for easy targets. A property held in a trust does not look like an easy target. They move on. When you pass away, your home transfers to your heirs through the trust without going through probate. No court proceedings. No public record of the transfer. No 6-month to 2-year delay while the estate works through the court system. The trust distributes the property immediately and privately according to your instructions. A revocable living trust requires an attorney to set up properly. It typically costs between $1,000 and $3,000 depending on your state. Compare that to probate, which costs 3 to 5% of your estate value. On a $500,000 home, that is up to $25,000 in probate, costs your heirs pay from the estate, versus $2,000 to set up the trust today. One critical point. If you already have a revocable living trust, verify right now that your home is actually titled in the trust's name in the county property records, not just mentioned in the trust document. Actually titled. The trust only protects and controls what is inside it. I cannot tell you how many retirees have a trust document sitting in a filing cabinet from 2019 but never transferred the deed. Call your attorney this week and confirm the deed transfer happened. Document number 5, the tax redemption record. This is the one that should make you sit up because it involves a Supreme Court case most Americans have never heard of and a government practice that 9 justices unanimously ruled unconstitutional after it had already destroyed one woman's life. Her name was Geraldine Tyler. She was 94 years old. She owned a condominium in Hennepin County, Minnesota. She fell behind on her property taxes. The county seized her condominium, sold it for $40,000, paid themselves the $15,000 she owed in back taxes and penalties, and kept the remaining $25,000 in equity that was legally and rightfully hers. In 2023, that case reached the United States Supreme Court. Tyler versus Hennepin County, 9 justices, unanimous decision. What the county did was unconstitutional. The government cannot take more than what is owed. The surplus equity belongs to the former owner. The ruling changed the law. States are now required to return surplus equity to property owners following a tax forfeiture sale. But states are implementing this ruling at wildly different speeds. Some have not fully updated their statutes, and the redemption window, the period during which you can pay back taxes and reclaim your property before the forfeiture sale, still has a hard line that in most states moves faster than any senior on a fixed income who received a tax delinquency notice during a medical crisis would expect. For retirees, this is especially dangerous. Property tax delinquency most commonly occurs in moments of acute personal crisis. A spouse dies and the surviving partner who never handled the finances does not know the tax is due. Or a major medical event depletes liquid savings and the property tax falls behind credit card minimums and utility bills. A gradual cognitive decline creates lapses in bill management before the family realizes what is happening. In any of these scenarios, the county begins the delinquency process. The notices go out, the deadlines run, and the family discovers the situation after the redemption window is already closed. Know the redemption timeline in your state before you are ever in a position to need it. If you receive a property tax delinquency notice, do not put it with the other mail. Do not assume there is plenty of time. Respond to it the week you receive it. Set up a payment arrangement with the county tax office immediately. Most counties will work with you on a delinquency payment plan because a negotiated arrangement is administratively easier for them than a forfeiture proceeding. And connect this directly to your annual senior property tax exemption application. Almost every state offers an exemption that reduces your annual property tax bill for homeowners over 60. Texas freezes school district property taxes permanently the year you turn 65. New York expanded its senior exemption to up to 65% of assessed value in 2020. These exemptions are not automatic. You have to apply. A lower property tax bill is the simplest and most sustainable protection against delinquency for a retiree on a fixed income. Here is your checklist. 5 documents. 1 afternoon. Protection for everything you built. 1. File a homestead declaration at your county recorder's office. Free in most states. 30 minutes. Search homestead declaration on your county's website. Find the form. Fill it out. Get it notarized. File it. 2. Sign up for property fraud alerts through your county recorder's office. Free. 5 minutes. Search property fraud alert on your county's website today. Enter your information. Done. 3. Call your title company and ask whether your current policy is standard or enhanced. If it is standard, ask what an upgrade costs. 1 phone call. 4. If you do not have a revocable living trust, contact an estate planning attorney and discuss setting one up. If you already have a trust, confirm your home is actually titled in the trust name in the county property records. 5. Check your property tax payment status right now. Make sure you are current. Make sure you have applied for every senior exemption available in your state. Know your state's redemption timeline for tax forfeiture proceedings. Open every piece of mail from your county tax authority and from the IRS immediately. None of this requires a team of attorneys. None of it requires significant wealth. It requires treating 5 pieces of paper as non-negotiable protection rather than optional administrative tasks. The gap between the retiree who keeps everything and the retiree who loses it is not net worth. It is the checklist. Dorothy in Pinellas County spent 4 months and $4,200 fighting for a home she already owned because she did not know about a free 5-minute county program that existed the entire time. The fraud alert existed. The homestead declaration existed. The enhanced title coverage existed. Nobody told her. The county had her address for 23 years and never sent her a single letter about any of it. You now know all 5 documents exist. You know exactly where to find each one. You know exactly what each one protects. Be the retiree who filed the checklist before the threat arrived. Before you leave, do 3 things. Smash the like button right now. 1 tap tells the algorithm to push this into the feeds of the senior homeowners who own paid-off homes and have none of these documents filed. Every like is 1 more home protected. Hit it. Subscribe to this channel and flip the notification bell to all. I release a new investigation into the financial traps and unclaimed protections the system built for you and never explained every single week. This is the archive. You want to be inside it. Drop a comment below right now. Tell me which of the 5 documents you already have filed and which ones you are filing this week. Tell me your state. Tell me whether your real estate agent, your estate attorney, or your county assessor ever mentioned the homestead declaration or the fraud alert to you at any point in your ownership. I read every single comment. Your answer becomes the field report that reaches the next retiree who lands on this channel and needs to know their vault is unguarded. I will see you in the next investigation. Stay sharp. Stay protected. And do not let anyone scam or creditor or government agency take a single dollar of equity from a home you spent your working life paying off.